Well, I'm excited to start another panel. I feel like this is my chance to be Phil Donahue. But I'm going to resist that urge. What a great first panel that was, and some of the topics that were discussed are going to lend themselves very nicely to what we're going to talk about. The title of this is How Can the NextGen Bar Exam and Changes in Licensing Promote Innovation in Legal Education? But it's important that we acknowledge that the major function of the center here was curricular innovation. And with Len Riskin and Jim Westbrook, along with Dean Dale Whitman and their one-out professors, they instituted the Missouri Plan, integrating ADR into the first-year curriculum, all one-out courses. And eventually, that shifted. It was extremely innovative at the time. And Len also contracted and consulted with other law schools, disseminated his ideas throughout the country, and really it became a model. And so when we think about the opportunities moving forward, we're going to start with how can the NextGen Bar Exam and changes in licensing promote innovation in legal education? And Kellie is going to take us through that.
All right. Good morning, everyone. We thought we'd have me start with just giving us a very quick overview of what the main changes to the bar exam are, so that we're all sort of operating on that same set of information. And so this is a really nice depiction of what the new bar exam will be testing, and to some extent how it will be tested. So the big changes, I think there are 4 main changes that are of particular relevance to the symposium. And one is there will be a reduction in the focus on knowledge that the current bar exam has. So there still, of course, will be knowledge of doctrine required and tested in the bar exam, but really trying to focus on what is considered foundational concepts and principles of law that all newly licensed lawyers should know. And so they're accomplishing that in primarily 3 ways. Fewer subjects will be tested. The ones showing up on your left side of the screen are the subject areas that will be tested. So fewer of those, down to 9 subjects from 13 currently, reducing the scope of coverage within those topics to focus again on what are considered the most important and foundational concepts and principles within the subjects. And then third, they are providing legal rules for some of the topics tested within those subjects, within the questions, to reduce the artificiality, some would say, of having to walk into the bar exam with so much law memorized and in your working memory to be able to take the bar exam. So that is probably one of the biggest changes. But what I think is especially relevant to this symposium and this audience is the second, which is increase the focus on skills. And so the bar exam, many would say it's not testing much in the way of skills currently. I don't know if that's entirely true, but it hasn't been very explicit about the skills that are assessed in the current bar exam. So in the NextGen bar exam, the skills are being expressly called out in what are being called the content scope outlines at the moment. For the current exam, there are subject matter outlines that are the equivalent. You won't find a list of skills in the subject matter outlines for the current exam, even though skills are tested. So in the NextGen bar exam, skills are being broken down into 4 big categories. Group A are the skills that arguably are tested in the current exam, and those are your issue spotting and analysis and investigation and evaluation. And so that's still part of the bar exam. The new skills in Group B, I think, are the ones that are of most interest and excitement to this audience, which is where client counseling and advising, negotiation and dispute resolution, yay, and client relationship and management are working their way onto the bar exam. It only took 40 years after the center was founded, that we finally got them on the bar exam. But this shows, I hope we've arrived, and then the group C, legal research, and group D, writing and drafting. Obviously, you have to write answers to the current bar exam, but we're not expressly, again, sort of assessing writing in an intentional way in the current exam, and that we will be in the NextGen exam. So those two, reducing focus on knowledge, increasing focus on skills. The other large change, I would say, is the design, what's called an integrated design to the exam. So instead of components, separate components that are kind of viewed as a test of knowledge in the multiple choice component, writing and knowledge in the essay component, and then skills in the performance test component, we are integrating knowledge and skills assessment in one design. And so it's not being built as three separate components. So that means that there could be, skills will be tested in the context, one or more skills may be tested in the context of one or more areas of doctrinal law or procedure. So there's going to be much more of a realistic feel and approach to the bar exam questions, I think, as a result of that integrated design to make question feel like a day in the life of a lawyer. What do they really do? And then the last big change I would say is a move to a client-centric focus, which I think also goes along with what the symposium is about and what dispute resolution is about, where we're focused on what will best serve the client. The current bar exam questions tend to be phrased more in the terms of what's the right answer to, looking at the law, looking at the doctrine, what's the right answer to this legal problem, instead of what would be the resolution that would best serve your client's interests within, of course, knowledge of the legal doctrine. So that's an important shift that I think is very complementary to dispute resolution. And so this gives you the knowledge, the skills, and it's all coming together into an integrated assessment. Are you ready to enter the practice of law? And then we wanted to also talk about, so not only is the bar exam changing, but there's a lot of study, at least at this point, with some actual concrete change happening in some jurisdictions with what's called alternative pathways to bar admission. So alternatives, sort of like alternative dispute resolution, I suppose, alternative to the bar exam. So instead of having people take a written exam for licensure, they will follow another pathway. And primarily those pathways consist of maybe a period of supervised practice after law school that you have to complete. And in that supervised practice, not just go out and practice under the supervision of a licensed attorney, but as you do so, you must produce certain artifacts, do certain things, turn those artifacts into the Board of Bar Examiners for them to also be part of that evaluation, not just your supervising attorney. Another pathway is the experiential education pathway, which is sort of taking the Wisconsin diploma privilege, where just merely graduating from law school is sufficient for admission in Wisconsin if you took certain courses, sort of expanding and formalizing that, and within that experiential educational pathway, integrating skills requirements, not just taking the doctrinal courses, but completing certain clinical or experiential opportunities in education, which may or may not involve like externships or summer practice. So there's a little bit of a hybrid going on between those two primary alternative pathways. The jurisdictions that are exploring these, for the most part, are still offering a bar exam alongside of it. How this will develop and what it will mean for legal education. I think the consistency is the emphasis on skills. So law schools who will maybe be in some of these jurisdictions in particular where these pathways are being adopted, have to think about what do we have to prepare our students for one of these pathways. And hopefully, if there's still an exam and a pathway, that's largely should be, from a licensure perspective, pretty consistent requirements, and hopefully the legal education that's necessary to prepare the students will be complementary there. But when things start breaking out into innovation, which is great, and things happening on a state-by-state basis, the challenge for law schools and for law students who are graduating is what will the pathway or what will the requirements be that I'm going to face where I seek licensure. And so that also presents a challenge for law schools as we have less consistency potentially of what we're trying to prepare our students for, particularly if we're a school that has students going to lots of different jurisdictions. So uniformity and portability may be diminished. Portability being the ability to take that bar exam result that you have with the UPE, send it to another jurisdiction and get admitted without repeating the process. So how will that work if you've gone through an alternative pathway to get admitted in one jurisdiction? Will you be able to use that process to seek admission somewhere else? And then last but not least, for some of us who have responsibility for ABA bar passage reporting, it's just going to make the nightmare even more fun than it already is. All I'll say about that. It is going to make it a little bit challenging in a few years as we settle through this. And then I have two links here. One, being the equal opportunity critic, I like to think of myself as in both the bar admission space and the legal education space, critic and cheerleader, is a link to lawyer licensing research that will tell you about all these alternative pathways, what's going on around the country, what jurisdictions are looking at this, what they're looking at. And then an article that came out in the Bar Examiner magazine that the National Conference of Bar Examiners publishes, and it had a column, Issues, Considerations, and Questions that jurisdictions should think about as they're considering or adopting or setting up these alternative pathways. So this is the lay of the land that we're currently facing is finally some modernization and change to the bar exam, and some exploration going alongside that may lead to further changes to the lawyer licensing process. And I think hopefully all for the better with, again, this increased emphasis on being able to actually get out and practice law and have the skills that are necessary.
What a concept.
What a concept.
So thanks for that great overview. And it would seem that the schools, as they respond, are going to fall into probably very self-explanatory categories. There will be schools that will decide not to do much. Right? They'll say the bar prep courses, they can help people prepare, and we're going to keep doing what we do, and we're attracting students that we think will be fine. There will be schools that do light revision. Right? They may examine the courses, they may look and see what do we need to supplement. And then there will be schools that might make wholesale changes. But when we think about dispute resolution, John, what are we trying to accomplish?
Well, I'm glad you asked that question. So what we decided as we were planning this was that we would focus on the latter group that I'm going to call him Brian. He's Dean Pappas, but Brian.
Nobody calls him Dean.
Nobody calls him Dean. You know, when you're really old, when one of your former students is a dean, I'm old. So is to talk about a theory of change for the latter group, the group that really wants to do something. And so the theory of change talks about 6 steps, and you can see them on the screen here. Identify long-term goals, backward map to identify requirements, identify assumptions about the relevant context, identify interventions to achieve the desired change, develop indicators to assess the performance, and to develop a written narrative to formalize it. So we can think about what, schools, I mean, each individual school needs to develop its own plan, and it could be from very little to a lot. And the first step would be to identify long-term goals. Now, in some ways, the NextGen bar helps in terms of identifying skills that are going to be tested, and in some ways, that may be a map to suggest what might be done. One of the things that I think we might want to suggest, particularly in the dispute resolution context, is to train students to be able to represent clients in mediation and arbitration and other alternative dispute resolution processes, not just to be neutrals. A lot of our coursework is to train people to be mediators and arbitrators. And for those of you who are students in this audience, sad news is you're not going to get to be a mediator or arbitrator until probably you have gray hair, like some of us. When you get out of law school, you're going to be representing clients in mediation and arbitration, because in places like Ohio, where Sarah, Professor Cole's husband, works, they're going to force you to mediate, and that's happening most of the places. And so you are going to actually be representing clients in mediation probably a lot more than you're going to actually be representing clients in trial, and certainly a lot more than you're going to be mediating in the short term after you're graduating. So one of the long-term goals might be, if you're interested, would be to prepare law students to be able to represent clients in mediation, which is not an easy thing. And the last panel, which I thought was just terrific, talked about some of the challenges in doing that. And part of it is to be able to, in terms of the conversation about self-determination and some of what Andrea, Professor Schneider's comments about preparing people before you get to a mediation or arbitration, so that you are really being able to help parties make their own decision, your clients. So those are some long-term goals, but it's a process where each school and each faculty needs to do it, and each school is different. So, the school in North Dakota, which has a faculty that, you could fit in a closet practically, is very different than the school here in Missouri.
Be a big closet, but you could do it.
Yeah. So each school needs to identify what its long-term goals are. And the idea of backwards mapping is to identify, what needs to be done. And having survived being on a faculty for a number of years, I can tell you that one of the challenges is what the faculty in any given school is willing and interested in doing. And some are very ambitious, and some are less so. And so it's a political process within a law school in terms of what the requirements are. And for some faculty in some law schools, it's a very exciting opportunity to have the NextGen bar and these alternative pathways. For others, it's scary or don't bother me. And so what needs to be done is it's a negotiation process within a faculty to figure out what any given faculty would be interested in doing. And then, of course, identifying assumptions about relevant context. One of the big problems or challenges is that people don't like to change. This is true generally, and it's true especially in law schools for lots of reasons. It's really hard to change. And so finding what changes individual faculty members are willing to do, and recognizing that not every faculty member has to change, and thinking about how it could be done collectively to be able to move forward to achieve the identified long-term goals, and to identify the stakeholder interests, recognizing that not all faculty need to change, and think about who the stakeholders are that you're dealing with. So you have students, you have alumni, you have employers, you have courts, and what all of their interests are in finding a solution. I mean, this is basically a dispute resolution, dispute system design process to try and figure out how each school can change to be able to achieve its long-term goals And then in terms of developing indicators to assess performance, there could be surveys of alumni and supervisors and lawyers and clients. Again, for the students in the audience, I hate to tell you, but a lot of clients do not like their lawyers. They find their lawyers do not listen to them very well. So if you're going to learn one thing from today, my suggestion is listen better. You know, we teach that in the lawyering class, and you know, we teach a lot of things. That's really important, and you should be paying attention to that all the time, and paying attention to what clients really want, which may not necessarily be to win in court or to get the most money, to listen to them, and to really satisfy clients, which is really the goal. And that's really what, you know, some of the things that Kellie was talking about in terms of the NextGen bar, in terms of client counseling and advising and client relationships and management, is paying attention to what the clients want. So in terms of developing indicators to assess performance, one of the things might be to do surveys of clients of our graduates to find out, you know, how they feel about what our graduates are doing. And of course, there are a range. You have some institutional, some large organizational clients, and they have some perspectives, and then you have individual clients who often have very different perspectives. So if you put all those things together, you may develop a theory of change to hopefully move forward to help law schools and law faculty and law students do a better job of representing clients, which from my perspective is the ultimate goal.
Thanks for walking us through, because process matters, right? We're not just thinking about dispute resolution in terms of options and skills and ways of adding to future lawyers, but also what's a process that would help us get there. So I really like that in terms of the symbiosis that can be created. Let's think about what the opportunity is. So if every law school and often states and courts need to think about this in different ways, what are the possibilities? And I'd love to hear from both of you on this. What exists? You know, if we think 40 years ago, what was going on at that time and how that has evolved, what might we be looking at as the opportunity that might help frame the next 40 years?
Well, we're dealing with, as I said, equal opportunity. I looked at life from both sides now in terms of bar admissions, the bar exam, the perspective of bar examiners, and then legal education. And something that I was well aware of while working in bar admissions is that the legal education and the regulators are not working together, even though they have a common goal. And I think both sides of the process of developing, forming the professionals in our legal system, we share the same goals of trying to produce competent, ethical, practice-ready lawyers, and we don't work very well with each other. And there have been studies going back decades, not just Justice O'Connor, but the Freight Report and other reports with, you know, here's how legal education needs to change, and then studies and articles and scholarship on the problems with the bar exam. And it's the bar exam holding back legal education. No, it's legal education. And so we spend a lot of time and energy, I think, pointing fingers at each other in this system instead of really working together and thinking about, with the increased emphasis on skills in particular and the alternative pathways that are being explored, you know, how do you, can you come up with a system that brings that realism, that involves law schools. The opportunity for skills assessment in a written exam is very challenging to pull off, you know, without driving the cost of the exam up, especially if you're trying to keep it written. If you want to get into you know, using a lot of technology and some gamification, if you will, around assessment, you can make a very realistic or more realistic assessment without having to have live client actors and things like that. But it's expensive. Law schools have clinics and have experience in teaching and assessing students' performing skills. So how can we take advantage of that while keeping what those on the bar examining side of the fence might see as somewhat of a conflict of interest? There has to be somebody guarding the hen house besides those who are laying the eggs. And so, you know, how do we get the two sides of this process to work together to really pull off effective skills instruction and assessment, and ensuring that newly licensed lawyers are ready to practice. And another big problem or challenge, not necessarily an opportunity, but I think, like the last panel was talking about AI and just generally technology and the pace of change going on in the world, neither legal education nor the bar exam process are built for speed, if you will. Both, it's very hard systems to bring about change in either of these systems. And so change happening in both at the same time and trying to get it to work together towards a common endpoint, I think would be a great opportunity that hopefully NextGen and schools looking at the bar exam maybe with a fresh eye, maybe with a fresh attitude. The bar examiners, I think, have definitely listened to legal educators as they've been trying to revise and redesign the bar exam. And so let's see a little bit more of that is what I think is a great opportunity.
And John, at the Landy School of Law, what would
God help you all.
what would you see as potential opportunities?
Well, a couple things. I mean, part of the challenge, and those of you who are administrators, and there are a bunch of you who are here, and faculty know that one of the problems is that legal education is expensive, and we don't do as much clinical or experiential education as would really be needed. And to really do a good job, we'd have to do a lot more, which would cost a lot more. So, I mean, one possibility that we talked about would be taking advantage of the NextGen bar, where there's fewer substantive subjects that are covered, and they're not going to be, as I understand it, asking questions about as many nitpicky little details that you need to remember, but more foundational concepts, that at the end of some of the bar courses you could have, you know, a class that would be a simulation, and in some ways it would flip what we did, what Lynn did in the first iteration of incorporating simulations often early in the courses, in the 1L courses. What some law schools and individual faculty could do would be at the end of a bar course, the last class would be a simulation, and maybe you'd have mediation. You'd have students who are in a mediation class who would be mediators, and you'd have a simulation dealing with a substantive area of law. I'm going to flip the script because the dean here is acting as a moderator and only asking questions. You have a lot of experience, so what's your answer?
Well, I'm not here to answer. No, I think about this differently than most people do. So I'm not speaking on behalf of my faculty in my law school, but what I get excited about are the idea that you don't need 8 credits of property. You don't need to have so much depth. And those are going to be really difficult conversations across this country. Because if you ask people who are teaching, there's so much more they could teach. And so where do you find those credits? But the opportunity to say, let's add a lab onto the end of this class. let's figure out what are the things that law students should leave with. I've been saying this for a couple of years now, and I don't know that it's making me popular, but it doesn't make sense that you go to law school, then you pay to take a bar prep course, to then pass a bar exam, that if you pass it, it doesn't mean you can do anything. That seems kind of strange to me. And I think that a lot of the inertia is that this is how we've always done it. And so the faculty were really great at law school, the way it was done. The lawyers had to go through and take the bar exam. I imagine that if you ask people who are just 2 years out of law school, should law students take the bar exam, they're going to say absolutely they should. I know that 3 Ls and 2 Ls feel very differently about that question. So I think there are opportunities, and I think back to 10 years ago at Michigan State, we had a contract negotiation class where everybody in the class, there were about 300 in the class at that time, did a contract negotiation. We had to negotiate in front of a professor, we had to draft a contract, we had them conduct an interview and that was very forward thinking at the time. I still don't know how it happened. But I think these are sort of the challenges are in implementing these and thinking differently about our curriculum. And so the next question I'm interested in thinking about are what are the challenges to doing this, in implementing changes in curriculum and changes to pedagogy. I think the theory and the practice can go together, but that requires an enormous amount of change in thinking and a big change in resources potentially as well. What are your thoughts about some of those challenges?
One thing that I think could be an opportunity, and it's also maybe a challenge first to get to the opportunity, but it connects to the integrated design of the new exam, is integration of legal education. So we can tend to be very siloed in legal education, and you focus on you're teaching this class, and our faculty have expertise in certain areas of practice or the law, and we have skills faculty and doctrinal faculty and these silos that exist. And so one thing that could be a benefit of the integrated design of the exam, of testing knowledge within skills, combining those two, is to have more of that happening across law school. So what the phrase of teaching across the curriculum, where we start to bring in those who are considered skills faculty into classrooms, and the doctrinal faculty and the skills faculty are working harmoniously together, because I think it is challenging in both of those silos to do it effectively and do it without the expertise and the specialization that both bring to the education process. So.
See, that's a challenge. Oh, there we go. You didn't hear anything I said up until now.
Could you repeat it over again?
Yeah. I mean, what Kellie just described is, as I think about being a former faculty member, all sounds wonderful in theory, but if you're a faculty member, gosh, I don't want to change. I've got, I've been teaching this course for a while. I've got my syllabus down. I've got the textbook that I'm using. I've got all these other things I need to do. I'm going up for tenure, so I need to write all my articles, and I need to do service, and I need to have a life. And so, doing all those things, and how you're going to get credit. So, one of the great ideas would be to have team teaching. Well, how the heck are you going to get credit for different, for two different faculty members teaching the same course? And how are you going to evaluate them for tenure? So there are all these great ideas. They're running into a lot of barriers, and again, part of that has to, dealing with that involves figuring out, within a faculty how they're willing to do that, which is not easy.
No, it really isn't. But the idea of breaking down silos and thinking about how things can be combined, and I think in that way, this NextGen bar provides a great opportunity, because it at least provides the impetus for thinking about it. You know, what are I think of remedies as a great class that combines a lot of different things that you've learned in other classes. But we haven't gotten to the point where legal education is scaling with infrastructure, the different learning that happens along the way. And so I wonder whether outcomes-based assessment is something that will become more prevalent within legal education. And whether long-term, and this is what I had argued at a Senate hearing in North Dakota, they wanted to know if we wanted a bill that would give us a diploma privilege. And I think a lot of people were yelling at me to say, yes, we do, but my view was that we didn't. We wanted the opportunity to demonstrate, based on outcomes-based assessment, that we didn't need this bar exam. To almost invite the bar examiners in to say, work with us on our assessment mechanisms and let us show you. And I don't know if eventually that's where this will go, where so many people are passing the bar exam that maybe eventually they'll say, we don't need it if you graduate from a law school that's doing these things. But getting there is not going to be easy. And I know one question that we wanted to talk about are, well, what resources might be out there that might assist people in thinking differently about their classes and doing this. And I happen to know somebody who's written a lot about this and has ideas for ways that this could happen, and he happens to be sitting next to me.
Well, it's hard, and I guess a lot of it has to do with collaboration within a faculty. I guess I want to go back to your question about the outcomes-based, which I don't follow this stuff closely. I know faculty and administrators really need to. The ABA has changed the standards and has required that more. I tend to be a little cynical and wonder whether this is kind of paperwork that doesn't really change the behavior of faculty or the skills of graduates. I mean, damn define it.
Well, some of this, I mean, the ABA is likely to increase the number of experiential credits required. I mean, it's 6 currently. There's a proposal out there to take it to 12 or even 15 or higher, and that in its own right is going to force changes as we rethink about that. So far, I think much of what they've done is probably lip service to outcomes, but I think there are other fields other than law that have a lot more history with this, right? We have schools of education that they focus intently on outcomes-based education. So I think one of the answers might be us becoming a little bit more interdisciplinary, looking to business schools, looking to medical schools, looking to schools of ed in terms of how they approach their curriculum. And I don't mean to suggest that the old school, Socratic method, that there's not a history and a place and that can't be extremely effective. But how do these things integrate? I've never had any student say to me, I really don't want to learn by doing. I've never had anybody say that. And so if we can do that meaningfully, and then we can add a whole new level onto this, because online education is sort of the gravity that's coming inevitable, that will, I think, further require that. You can't simply put a camera on somebody to teach an online class. That just gets a little bit tedious and tough, especially if we're talking about a doctrinal course or there are large numbers of people in the class. You have to flip it. You have to think about how to make it active. So I think there's a lot of converging pressures that might enable us to make the change. But then that gives us the opportunity to then, and I'm gonna mention this, to use, say, full semester simulations, or to think creatively about how to do things to integrate the doctrinal area with the dispute resolution mechanism with something that's going to feel very realistic to what people are going to experience. So could you tell us a little bit about the full semester simulation and how that works and where that could fit in?
Again, it's a great idea that probably very few faculty would be willing to do. As far as I know of one faculty member who does it, Chris Franklin at New York Law School teaches family law, and the entire semester is, I don't know if it's a single simulation or multiple simulations, but she says that she teaches all of the same doctrinal law that faculty who teach law, family law do in other courses without doing any simulations or a lot of simulations do. Now, that requires a lot of retooling, and again, faculty are busy people, and they are comfortable doing things as they have been, and for lots of understandable reasons. So, I mean, that would require a lot of change. I was talking with Lynn about how the first year, you know, and this wonderful experiment that Dean Whitman and the faculty developed 40 years ago did, and part of it was that they had some financial incentives to write simulations. So, although that was only part of it, but that apparently helped, you know, it's a little sugar. So that may be one thing. I mean, it's just shocking to me. I mean, I think it's an open scandal that we, you know, students can graduate from law school without ever having talked to a client. Can you imagine a doctor graduating from medical school without ever having laid a hand on a patient? And yet, given the structure of legal education, the radical changes that would be needed to do that. I mean, so it's really would be an incremental process.
And as you know, it's expensive. The clinics are great. We have really good clinics here at the zoo and several of them. Yeah, and I think a lot of law schools have developed clinics. It is the expense and then how many students can you serve through the clinic. So it's sort of like, how can we take that value and education that's going on in those sorts of courses and be able to take the time and the cost associated with it to spread that benefit across more students.
Do you think that some of this might end up also resulting in greater specialization for law schools? Because some of this might be, ABA has certain requirements on law schools, but largely, we're all doing the same thing. We have different specialization areas, but if you think about the curriculum writ large, there's very little difference. You go into a torts class in North Dakota, it's going to be virtually the same as the torts class here versus the torts class almost anywhere. Do you have a sense of whether there could be greater specialization?
That's really getting at something that has always kind of been an issue that I keep wondering when or will the legal profession ever move off of the general license, which is a challenge. One of the criticisms, people who have to take the bar exam. Increasingly, I think even in law school, students are starting to specialize more or come out of law school thinking they know what area of practice they want to go into. And it's like, I'm going to be in criminal practice. Why do I have to pass this part of the bar exam? I'm never going to do family law. Why should I have to be tested on that? Well, it's a general license, and so the license allows you to get out there and do anything within the bounds of ethical responsibility. So I think, though, and that could be where I think what you're teaching in law school and how much that's where you get to what is it that lawyers need to know, what is that foundational knowledge that all lawyers should have, that walking around in your head, you just know these things. What are the things that we learn in law school and develop as lawyers that allow us to change practice areas and take on matters that we have never studied or practiced in? We're able to do that. So what is that thing that we're teaching about knowledge and about skills, and can we focus in on that and not feel that we have to cover the waterfront because there's too big a waterfront anymore? So how do we get it down to what is really the essential thing that we need to be teaching and then assessing for entry to practice?
That's a great question, Brian, and I want to go back, let's see,
To your theory?
No, to yours. I'm going, never mind. Anyway,
Kellie's on the next panel.
yeah, really. Kellie had this slide about the, yeah, okay. We've only got 15 minutes, and we'll figure that out.
We don't want to miss the next panel.
The point being, you know, the challenge is partly is the bar exam, and even with the NextGen bar, you know, compressing the subjects, you know, that's, I think, part of the reason why, you know, the curriculum looks pretty much the same across the board. I mean, one of the things that's a radical idea that actually those of us in the dispute resolution field might have at least a theoretical contribution. Again, it's hard for me to imagine that this would actually work, would be to focus on these trans-substantive skills that are now just being introduced into the NextGen bar, because those are things that whether you teach and whether you practice family law or real estate or torts. I mean, when I graduated from law school, I didn't take a course in real estate law, I didn't take a course in family law, and guess what? When I graduated when I went into practice, those are the things that I got jobs in. And so, you know, God help our clients that, you know, that I was inflicted on them. If I had more skills training about these kind of client relationships and skills in working in problem solving, in disputes, in negotiation, hard and soft, those would help across the board. But unless we are going to get rid of the bar exam, which I don't think is going to happen in my lifetime, I think we're not going to be able to do that. It's going to be pretty much similar across the board, would be my guess.
So I believe we have a little less than 10 minutes left, but let's open it up to some questions. Yes?
A couple of comments and then a big question. One optimistic comment is, from doing a lot of ABA site inspections, my sense is that teaching is beginning to change. The majority of people coming into teaching now have had a clinic, an externship, or a skills course. And so some of that is seeping in. I've seen that percolating across the country. Another small comment is, even though it's costly to think about major transition from all doctrinal to all clinical, even stuff in between, we've explored some small steps. And one is, if every doctrinal faculty member would ask the students after discussion of every case, would this case have been resolved if it hadn't gone into litigation or gone to trial? And my colleagues who have tried this have said, well, it does take an extra 5 or 10 minutes, but I've learned a ton from what my students do or don't understand about the world of legal dispute resolution. So that's another really small lesson, not too expensive. But my big question for Kellie is, those of us that teach skills need to know how the professional skills components are going to be evaluated. So we are prepping them. Here in Missouri, our 2Ls now will be taking the NextGen bar exam in the summer of '26. I've seen very little about how they're going to evaluate the various foundational skills. And so if we knew more, we could prep better, whether we're teaching doctrinal or clinic courses. And do you have any insights?
When I said not built for speed, I was definitely thinking about, and I worry, and I said before I retired from NCBE, I said, good heavens, it's taken us this long to make what aren't huge changes, or to try to make changes to the bar exam. By the time we get this implemented and rolled out and jurisdictions are actually getting it, it's going to be outdated. You know, so this general sort of, how does this process, education and licensure, keep up with change? I'm sorry, that prompted another thing for me, but I 100% agree that we aren't seeing enough out of NCDE to be able to know, and this is something that I think especially in the new skills, we're not too worried about the changes going on with the doctrine, integrating the doctrine and the skills, but what questions are they going to be asking? And one of the things in teaching lawyering this year, and I taught legal research and writing last year, both of which are skills courses, and they're The things where students, I think, it helps the doctrine come alive, but it's also, when it's a skills course, you know, as I say often in class, it's about understanding, and there was a comment about, you know, do we teach them how mediation should be or how it's actually being practiced? You know, you've got to show them what it should be with some realism. And then you've got to be prepared and be prepared to exercise judgment and be flexible. And it's that flexibility in skills, how you carry out exercising those skills as a lawyer, that makes assessing them in a written exam, I think, especially challenging. And you can come up with the questions, but then what are the answers? We're used to the bar exam being, or any exam, what's the right answer? You're looking for a certain answer. And sometimes we're moving in an area where, as the law is a lot more gray areas than necessarily the black and white areas. And so as you move into some of those things where we're moving away from what's the right answer, and that's somewhat going to be reflected in change to some of the multiple choice questions. So they're going to start to have questions that are not just pick one right answer from these 4 choices, but pick 2. What are the best 2? What are 2 things you would do or you wouldn't do? So there's moving into, with the skills emphasis, more gray area. Now, how will they do that, and how will it be?
And when will they tell us?
And what?
And when will they tell us?
It's a lot of work going on getting, much like in law schools, with getting faculty to maybe think about how to change the course that they've been teaching and the way they've been teaching. NCBE has to teach drafters. No, we're changing the way we're drafting questions and what we're trying to assess. And so we're teaching a lot of old dogs new tricks in both camps, I think. And it is taking longer than one would hope for an exam that's barreling towards us, and we don't really have samples of what it should or will look like. So I agree, the frustration, I sit in a unique place of feeling, I know, I still feel responsible for that, but I'm not responsible for that. They need to get these questions out. We need them now. So I just join you in that.
A quick follow-up. I think your suggestion or your comment about what colleagues teaching doctrinal classes is a terrific one, and something that could be done relatively easily, which is, after discussing a case, would be to ask what the client's perspectives might have been, which almost never show up in the appellate case reports, and particularly the excerpts that are in the text, but those could be very useful conversations, and it sounds like some of your colleagues are doing that.
So I think it's really hard to make changes in legal education. We all know that. I wrote an article 30 years ago calling for the abolition of bar exams and the replacement with the Wisconsin system. And the Wisconsin diploma program, I was a graduate of Wisconsin. I argued in the article that I was just as prepared to represent my clients effectively as anyone who took a bar exam. And bar exams were a waste of money and a waste of time. You can have more curricular changes more effectively when you don't have to teach so many different courses and you don't have to require so many courses. So at Wisconsin, my students, all of whom were going to graduate and most of whom were going to practice in Wisconsin, took 16 credits their 3rd year and worked in my clinic. There were 16 students. We partly financed it with the public defender's office because we handled real cases. Those 16 students, every one of them was ready as soon as they graduated to go to a public defender's office and a district attorney's office and work right away. They were incredibly competent and they all got a job right away. Now, we can't do that in most law schools because we have to prepare them for the bar. So we can't get as creative, and ultimately I think we could do a whole lot better. The other part of this article talked about the Canadian model, because the Canadian model actually has specialization and certification. And let's get rid of this ridiculous idea that when our students graduate, they're competent to practice in every law area. That's absurd. They aren't. So let's have specialization, and let's train them after they graduate. Instead of spending money on a bar exam, send them for 2 months to a training school so they're then prepared and specialized to come out certified to practice in a particular area. And if you want to be a general practitioner, then you get certified to be a general practitioner, but there aren't many of those. So, 30 years ago I wrote about this.
Well,
Nobody read my article.
Maybe in 30 years we'll do that.
Yeah. Hey, they did it in Wisconsin.
So I was wondering if, related to Rod's comment and also John, your comment about not feeling super prepared on day one to represent people in family law. I'm wondering, though, with changes to the bar exam, who's really going to be impacted? So here's what I have in mind. There's lots of folks in this room probably who graduated from law school before 1984, before integration of these skills, and they eventually became really good mediators and negotiators. And there are people who graduated after 1984 and they got some education and that we're doing now in client counseling and mediating, and eventually they become really good at it, even though they didn't have to study for a bar exam that was so focused on it. So these changes are going to force us to do a bit more. But really, who's it going to really impact? Is it impacting graduates just in their first year? And maybe by year 2, they'll still be where they would have been otherwise? Or no, this extra bit of education will last 3 years, and then they'll be where they otherwise would have been. Like, how really important is, now that we've already integrated a lot of this into the curriculum, how important is it? What kind of impact is it really going to have on lawyers? Does that make sense?
It does. Well, I was going to say, one of the things that I think is one of the biggest values of our lawyering course that we have here is introducing our students in that first semester of law school to, it's not just litigation, and that client focus of serving your client. And I think those are really, really valuable things we're bringing. So do we need to test it on the bar exam? Do we need to have a bar exam? That's always a great topic for debate, especially in certain audiences. But hopefully and there's always, that's part of the finger pointing is, we have to teach these things because they're on the bar exam. The bar examiners are like, we have to give a general license, so our responsibility is to test what under the umbrella of that general license, and look, what we are testing are the things that you have been teaching in law schools for decades and decades, and so we seem to be yoked to one another with this, what must be taught and what must be assessed for licensure, and that's where could we plus the courts and the boards of law examiners, but really the courts, Supreme Courts, state Supreme Courts around the country, in terms of would we ever get them in the conversation in this whole thing about, I think technology now allows us to move away from that general license more easily because we can readily see what somebody's certifications, education, expertise, experience, abilities are, and let people develop that expertise and experience in law school, after law school. The other factor, a little bit of what you're mentioning there, is I think there's been this trend, and maybe still there, of employers not wanting to invest in doing some of the training of new graduates that used to happen, and maybe is still happening in some places, but not as much in some others. But the bar being involved and having some responsibility and understanding when you hire new graduates, there's probably going to be some gaps, some things that you're still going to have to fill in for your client base and what you hire this graduate to do.
A quick response. in essence, I'm hearing you ask, what difference does it make?
Well, not what difference did the changes that we've already made, because I think they've been really great and important. So right, it's not any sort of, any skepticism about what we've done here. It's really now about, now there are changes to the bar exam, that's going to make some more changes, and I'm just wondering what now the incremental value of that will be.
Well, I want to go back to the benefits of, we're supposed to wrap up, but I'm going to keep on going anyway. I'll go back to what we've already done. In 1982, Leonard Riskin wrote one of the best articles, Lawyers and Mediation, and he talked about the lawyer's standard philosophical map, which basically says lawyers think about, you know, who's going to win and lose and resolving disputes according to the law. That was 42 years ago, and from practitioners that I hear about, people say that's still the way lawyers think now, or many lawyers think. Now, there's probably been some incremental improvement, but I guess it's a question of how much, and it's a slow, long process, which I guess we all recognize, so I'm going to stop.
Well, thank you, everybody, for the great panel. I enjoyed working with the two of them, and we look forward to the next panel after lunch.